case involving the spread of hepatitis to hundreds of people, to the reuse of unsterilized EEG needles, or to quasi-criminal offenses such as fraud or for overbilling OHIP. OHIP is the Ontario Health Insurance Plan, which pays the doctors for the services they render to their patients. Generally, the appearance on the other side of certain counsel, on the defense side of certain counsel, because only a select few firms are on retainer by the CMPA, and most lawyers will know who they are, is a good indication that the physician has been granted some form of CMPA assistance. The CMPA retains the lawyers and defends the cases. The physician has little to no input regarding the conduct of the case. The CMPA Case Review Committee decides the conduct of the defense. They decide whether the case is defensible or whether it should be settled and for how much. As their name suggests, the Canadian Medical Protective Association, the operative word is protective. The function is to protect the doctor. That is, to protect the doctor's reputation, and that is done by putting forward a formidable, numbing defense. This is an important and crucial aspect to be noted. The CMPA is not an insurance company per se and does not operate like one. The difference is that an insurance company wants to get rid of a case at the cheapest price possible. I think that's been mentioned earlier, and it's universal. It's business. This is not the situation with the CMPA. Decisions are not made based on costs to defend or making nuisance offers to get out of an action cheaply. Preserving the doctor's reputation by putting forth a formidable defense is foremost for the CMPA. If the CMPA has made the decision that a claim is defensible, then settlement, short of a dismissal of the claim without cost, is by and large not obtainable. So in the context of one case, a vigorous defense may not be of significance, but as overarching policy and practice, it may act as a significant deterrent. In 2003, the CBC News broadcasted a program entitled Inside the CMPA, a first in-depth look at the Canadian Medical Protective Association. The CBC is the state-owned Canadian Broadcasting Corporation. It was reported in that broadcast, the CMPA, is driven by protecting the doctor's reputation almost at all costs. The CMPA would spend $100,000 protecting the doctor against a $5,000 claim. The CMPA may keep a low profile, but if you sue a doctor, it's almost always the Canadian Medical Protective Association running the show. 95% of Canadian doctors are members. Just how far would the CMPA go to protect the doctor? The legal strategy is well worn. Deny the doctor did anything wrong, even when the negligence seems pretty clear. That's their strategy. It's coordinated across the country. It's intended to make these cases as difficult as possible for plaintiffs. The truth is that few plaintiffs or their lawyers survive the CMPA's suffocating tactics. Although the foregoing was stated in 2003, the basic philosophy has not changed much since then. The CMPA receives its funding from the public. In 2008, Ontario taxpayers, the province where I am from and the largest province in Canada by population, spent $112 million to subsidize medical malpractice fees paid by doctors. The doctors themselves paid $24 million. This means that taxpayers picked up 83% of the costs of medical practice. In effect, the injured plaintiff taxpayer significantly contributes to the strong-arm defense he or she faces. In 2012, membership fees, together with the investment income, totaled the sum of $2.6 billion. That's billion with a B, which formed a reserve fund that was available to defend doctors. National statistics from 2012 CMPA annual report note, and I can see at the mention of the word statistics, eyes glaze over, but I'll be brief, but it's informative. 869 legal actions were commenced. 10 legal actions proceeded to trial were won by the patient. 63 legal actions proceeded to trial were won by the doctor. 444 legal actions settled out of court. 514 legal actions were dismissed, discontinued, or abandoned. So at trial, statistically, plaintiffs have a 13.7% chance of being successful. Or to put it another way, plaintiffs at trial have an 86.3% chance of losing. Some of you may say that the plaintiff would stand a better chance going to Las Vegas. If the CMPA believes they have a defensible case, then they will vigorously defend it regardless of costs. To some extent, this overlaps with regard to traditional liability insurers as well. If the insurer does not perceive there being a genuine risk, then the plaintiff is in for a fight. Although offers may be more obtainable from a liability insurer than from the CMPA for reasons I stated earlier. But overall, whether it's the CMPA or traditional liability insurer that is defending the claim, it seems that they, by and large, the approach is the same, which is no amount of money is spent to fight the plaintiff, but little or none is paid to appease the plaintiff. Why? So not as to be perceived as being a soft touch by putting forward a formidable defense. Apparently the defense believes, as a business model, this approach has a salutary effect on the bringing of claims. Now, having said everything about the CMPA, I don't want you to think that they don't settle cases. They do. They do settle cases. The $2.6 billion that they have in the war chest is also used to compensate plaintiffs. In 2012, the CMPA paid out $249 million in judgment awards and settlements, and that's according to the 2012 CMPA annual report. If the CMPA has determined that the doctor clearly made an error, actionable in law, then the focus turns to the level of damages. After all, what better place to protect a doctor's reputation if not at mediation, where everything is confidential and settlement documents may contain confidentiality clauses? Of course, even in defensible cases, mediation offers the same protection. But even if damages are the only issue, there's still significant pushback regarding the level of compensation. One prominent medical malpractice lawyer recently said to my former partner that his client, the CMPA, pays him a lot of money to dispose of a case, so why pay a mediator? That seems to be the prevailing attitude. But it may be that by holding such a view, the CMPA is misdirected by taking such a strong strident stance to resisting claims, particularly in defensible cases. If the purpose of such a stance is to protect a doctor's reputation, then, as I stated earlier, mediation will produce the result whether or not the case is defensible. As such, protecting a doctor's reputation appears to be secondary to deterring claims. To this end, I am not aware of data which indicates that claims have been reduced or claimants have been deterred as a result of taking such a stance. Maybe the CMPA has statistics that it keeps confidential. Maybe the evidence is just apocryphal. However, such an approach comes with an unquantifiable cost: the possibility of establishing a dialogue towards repairing the patient-doctor relationship, or of providing an opportunity for emotional healing is lost. The opportunity of exploring and achieving alternative forms of resolution to the mutual benefit of all concerned, as opposed to a stark, harsh, one-dimensional solution presented by a trial, is lost. In my jurisdiction, we have a procedure known as mandatory mediation. It sounds a bit like an oxymoron. It entails that before a case can be set down for trial, it has to be mediated. It went through different stages. Initially, it was that mandatory mediation was 90 days, I believe, after the filing of the statement of defense. But what was found was that a lot of cases are started, but they all follow their own pattern and evolution, and so they bottlenecked, and there's a lot of cases that got tied up at the early stages, and a lot of parties were just not ready at that stage for mediation. In personal injury matters, the injuries had not yet matured, or it was unknown whether the injuries was going to be permanent or not. The quantification of potential damages had not crystallized. So it was decided to alter the process and do it at a stage that where the parties thought if they're ready to go to trial, before they can get there, they have to first go to a mandatory mediation. And there's a process for that of what's required. It's basically, if it's a mandatory mediation, it's 3 hours at a fixed price set by the court by a tariff if the mediator wants to accept the mandatory mediation rates. And then thereafter, it's an hourly rate at the mediator's hourly rate if the parties want to continue. So that's the mandatory mediation process in the nuts and bolts. And in the context of cases other than medical malpractice cases, where at least costs are a factor, mandatory mediation is effective. And settlements have resulted in many instances, even though the parties going in never expected it. For reasons I stated earlier, this is not so with medical malpractice, where costs to defend are not a consideration, and settlement is not really an item to discuss short of a dismissal of the claim in defensible cases. Accordingly, if it has been determined by the CMPA that the case is defensible, there's usually a courtesy call to the mediator to not spend too much time in preparation, as the parties have already agreed to fail the mediation. That is, to hold a pro forma mediation in compliance with our rules of practice so that the case can be set down for trial. Sometimes, though, it may be worthwhile to know, as a mediator, if it's possible, which party requested the mediation. If it's the defense, it may be a signal that the defense has made a decision, i.e. the CMPA, that the case is not entirely defensible and settlement should be explored. It doesn't alter the process, but it's good to know who's requesting if you can find that out, and it's not always divulged, and sometimes it's mutual. So you might say, after hearing all this, what's the point of mediating a medical malpractice lawsuit? And I say to you, that is precisely the point. For a mediator, what's in the way is the way. It may be still worthwhile to have an airing and discussion of the issues, no matter how perfunctory it may initially appear. There is value in a failed mediation. It presents an opportunity for each side to learn more about the case from both sides of the divide. It presents an opportunity for reconsideration and reflection. The parties can glean insights from the mediator's comments and approach as a barometer of an impartial response to the case. A judge's view may be no different. So at mediation, the parties should be prepared to listen, learn, and be flexible. For the mediator, the parameters of a mediation have to be established based on the nature of the case, the parties involved, and the nature of the representatives involved, especially those at the mediation and those behind the scenes. It is highly unlikely that either party at mediation, after so many years of litigating, will suddenly be convinced of the other side's position. If the question of liability cannot be resolved, for example, in mediation, then perhaps efforts should be directed at trying to reach an agreement on damages and letting the case proceed to trial on the issue of liability. In this way, costs and time will be saved. It is therefore important that all pertinent documentation be exchanged well in advance of the mediation. Medical expert reports addressing the issue of damages and liability, cost of future care reports, loss of income reports, accounting reports, actuarial reports, economist reports, etc. It's a layers of experts and becomes a trial of experts. One side with their Nobel Prize winners versus the other side with the Nobel Prize winners. And that's the contest. And sometimes the plaintiff is lost in the shuffle. But, as I said, this mediation is in the shadow of a lawsuit, so you have to keep that in mind. But late-breaking reports that significantly alter the landscape given and delivered at the last moment, stymie the potential for meaningful negotiations and settlement opportunities. So the best way of resolving a medical malpractice lawsuit at mediation is to prepare in advance as if it is proceeding to trial. In this way, the mediation process can be maximized to its fullest potential. You don't want to sit at mediation and hear one party hear the other party speculate what may be. They got to have some evidence to at least support their position, given who is on the other side. It may not be in other cases, but in medical malpractice, given the, as I said, the parameters, the four corners of the contest, that you have to be prepared, otherwise you will not get going. Or, as we say in Canada, to first base. I don't know how that translates in cricket. I have had mediations conclude where the solution was that each party agreed to make a donation to a foundation or to a charitable organization, or where one party received compensation in the form of gift cards that the other party sold at a discount or gave away as promotional vehicles. The gesture was still appreciated and valued